Miss Aurorah is back. Secured entrepreneurs, in this video, Miss Aurorah is going to answer the questions that you all have been emailing about living trusts, living wills. Miss Aurorah, what's the difference between a living trust and the will? Miss Aurorah, should I have a living trust and transfer assets to the trust, or should I have just a family trust? Or like, you all have been bombarding the email with these questions, and I want to thank you for emailing. Please continue to do so at info@aurorahdayconsulting.com. So in this video, Miss Aurorah is going to answer all of your questions regarding the living trust, and should entrepreneurs actually have an interest in creating living trusts. All right, can we do that? Okay, so for those of you who do not know who I am Miss Aurorah Dey, and this is the Secured Entrepreneur Movement. All right, so let me start off by answering some of the primary questions about the living trust. First of all, what all of the secured entrepreneurs need to know, and what all of the entrepreneurs who are just visiting us, hey, okay, what you need to understand is that the living trust is I think it's important. I believe that the living trust is important simply because, first answer, the living trust, yes, it's going to avoid probate, but it's only going to avoid probate when it is funded. So if you do not give that trust any assets, really it never exists, okay? Because what some people do, and this is according to a lot of the documents that you all sent up here via email. You sent these documents to Miss Aurorah, okay? And what you're doing is you've made lists of things, okay, that you feel are valuable, but you did not clearly state that these things actually belong to this trust. You did not clearly state, well, were they a gift? Did they belong to the grantor? Because for the most part, many people are going to create this living trust where they serve as the grantor as well as the trustee as long as they are alive. But this is King David. King David and I came out tonight to see Marlon Wayans, okay? And they didn't allow anybody to do any videos or photos until after he had his set. They said that possibly it's going to be a special somewhere, so clearly it's going to stream somewhere at some point. Anyway, so what many people are doing is they are listing themselves as the grantor as well as the trustee. There are no tax benefits to that because that is a grantor trust. The tax benefits come when the grantor is just a grantor, the trustee is just a trustee, and then we have some beneficiaries, right? Okay. So in the living trust, you should have things like your funeral plan, your power of attorney, financial power of attorney, medical power of attorney, things like that. And then you would point to where assets actually are. So, you as far as the last wishes, right? You would say, the home, this list of valuables, the art, the jewelry, the rugs, whatever it is that is valuable to you that you want to entrust and pass down to people, you would point to the actual trust that those things are in. You would point to who the trustee is there, things like that, and create a living trust that is irrevocable so that there are tax advantages. Now, we do the double whammy here at Aurorah Dey Consulting. We would actually create a bona fide irrevocable family trust, and then a living trust would be inside of that so that there is a clear understanding of what it is these individuals actually do want upon transitioning, and then it would be pointing to other trusts or other places, other entities where things are, and the managers who control it, the trustees who control it. These are the things, because if you don't do it that way, here's another mistake that we see a lot of people make. They will create living trusts and name the trust after themselves. It would be like the John James Living Trust, right? Once again, if you don't fund this trust, it technically does not even exist. So they go and retitle property under John James Living Trust. And what's happening? There's no tax advantage there, because you have named the trust after yourself. You're acting as the grantor and the trustee. You're not getting the result that you are actually desiring to get, as it relates to the purpose of why you created this trust in the first place. And then the next thing that many of you were asking was about, this will and the testamentary trust. Now, understand this, that we don't advocate the will around here. We don't do the will situation here at Aurorah Dey Consulting, because we understand that the will is just landing you in probate. And there's too many people who have no interest in having their families go through probate. The length of time, the potential cost, depending on how large the estate is, forgive me for the hair, depending on how large the estate is, things like that. People really don't want their family members to have to go through any of that. So we have had many clients who have opted to have a financial institution act as the trustee. Okay, we know that. Or they'll have someone that they actually trust act as the trustee, so that this is a smooth transfer when they do these living trusts and set things up like that. The will situation, we already know, is you have an executor or an executrix, and upon your transitioning, your estate would have to be probated. It absolutely makes no sense. So we don't advocate that. The answer to this other question some of you asked, you wanted to know how it is that the testamentary trust actually comes into play. Well, in many cases, that testamentary trust is coming into being by way of a will, but property still is going to be passed through probate, because it started out as a will. The will was drafted first, and then upon instructions, there is to be a trust, but the property of the estate, passing through probate into that trust. That's the whole glitch behind the testamentary trust, which is why you should already have your trust in place way before you think to do anything. I mean, of course you want to have your trust in place way before your transition. It's been a long night for Miss Aurorah. So now let me sum this up, because some of the documents that were sent here did not have a page for both the grantor as well as a notary. This entity, the living trust, must be signed by the grantor and a notary. It must be notarized. I did not see that in the documents that some of you sent here. So please make sure that when you are creating your living trust, you have a page that will include your signature as the grantor and a notary signature. Okay, because just like a will would have to be witnessed, your living trust needs to be witnessed. Okay, again, you would make a list of the things that you are entrusting into this trust. If you are serving as the trustee, yes, you must designate someone to take over the role of trustee upon your transitioning. So the entity will always have grantor, trustee, beneficiaries, right? So now you have the list of the things that you desire to entrust to this entity, right? Okay. What I'm telling the secured entrepreneurs and the individuals who sent these emails is that if in fact you plan on retitling some real estate, please do not name this trust after yourself. And it's really not a good idea if you're doing that to act as the trustee, serve as the trustee at any time. That's all I'm trying to share with you in this video, that you can go ahead and make the list. You can have the list of assets that you are entrusting, because once again, as I'm saying, this must be a funded trust. So that is part of how you would do that. Okay. That's all fine and good. But where you're going to mess up at is serving as the trustee. Okay. And you are creating taxable events when you serve as the trustee, because what's happening is that it would be deemed a grantor trust, and all of the value inside of that entity would just be, it would still be part of your personal estate, which is what you're trying to avoid in the first place. Okay, so I just want to make that very, very clear. In addition, again, stop naming it after yourself. Give it a real name. Give it a name, because this is it's an operation. It's on go. You're operating this entity while you're alive, which is why, once again, you need to make a sandwich. Think about it. So if you have not already, please go into the description box and click the link below. Get the Trust Basics course. It will be at the holiday price for the remainder of January. Okay. I think that's all I want to say in this video. I'm going to get into the whole special needs trust that you all have been asking about as well. I'm going to make that video now. Okay. And I'll post these videos on the same day. How about that? Okay. So that's all Miss Aurorah wants to share in this video. You all know you can find me, Miss Aurorah Dey, at AurorahDayConsulting.com. And until next time, ta-ta.